Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times in divorces, people will take the position that, okay, I know I have to split my assets. What if I don't tell them what all the assets are? Or what if I don't disclose to her that I have money in this account or that account? Well, any attorney worth hiring is going to tell you that you have a responsibility to disclose all the marital assets, and you don't get to decide which is a marital asset and which is not. Because even if you own a bank account beforehand in your own name, it's arguable that the increased value of that account over the years with interest and all that, that piece may be a marital asset that we have to discuss. So you are best advised to disclose all your assets. You disclose them all. Those that are not supposed to be part of the discussion for the divorce because they're non-marital, those will be taken off the table. But the moment you make the decision and you start hiding assets or failing to disclose assets and then they get found out later, there are serious consequences associated with that tactic. In a lot of cases, judges will actually say, had you told us about this potential asset, we probably wouldn't have given your ex any of it. But now that you violated the law by failing to do so, we're awarding her or him half this asset, or it could be all of this asset depending on the circumstances. I'll tell you where this comes up a lot. And this is really what you got to watch out for. Sometimes there'll be a divorce that comes up at a time when one of the parties has some kind of case pending because they were wrongfully discharged or they were in an auto accident or some kind of thing that they personally suffered that the other spouse really didn't directly suffer, but they had a loss and they have a lawsuit pending for that. Well, the duty of the person involved in that in a divorce is to disclose that lawsuit as a potential asset. Now, in most cases, the court will say, well, you know what? Thank you for disclosing it, but he's the one who had the accident. He's the one who had the pain and suffering. He's the one who's going to the doctor. Whatever recovery there is, we're giving it to him. You didn't really participate in that. But if he fails to disclose that asset, the court may very well give a piece of it, if not all of it, at its discretion to the other side, because of the non-disclosure. So non-disclosure is not something to be trifled with. You should discuss all your assets. Anything that could be potentially brought into play, you should tell your lawyer, and it should be appropriately disclosed. And then how it's handled, whether it's handled, your lawyer can argue it's separate property or whatever, it's premarital, and that's something that the lawyers argue about. But the failure to disclose could be a very, very dangerous tactical mistake. If you have any questions about your case, of course, reach out, and we'll be glad to help you out.